Good afternoon, everybody. Welcome to another question and answer session. My name is Samara Belitzky. I'm a lawyer at Samfiru Tumarkin. I work primarily out of the Ottawa office, and I will be here for the next half an hour or so to answer all of your questions. So please send in your questions. If you've seen this before, you know the drill. Send in your questions, anything related to employment law, issues in the workplace, most commonly recently, issues related to vaccine mandates in the workplace, anything related to COVID-19. Traditional employment law issues are also welcomed, regular terminations, any issues in the workplace regarding health and safety, any issues with respect to severance. Please send in your questions. I am now here, like I said, for the next half an hour or so to answer any of your questions that come in. So if you have an issue that you are concerned about, if you have a question, if you know a friend or a family member who's dealing with an employment or workplace issue, please send in your question and I will be more than happy to answer and direct you to some legal advice or the best way of dealing with your situation. So I will get started. As the questions start to come in, I did have something that I wanted to talk about this afternoon because it's something that has been brought up a lot over the last few weeks. And it's not vaccine mandates and it's not related to COVID-19 directly, although I do think it is one of the consequences of the pandemic that we're seeing, which is that employers have been starting to implement or introduce new employment contracts. So what we're seeing a lot of, especially towards the end of the year, it seems to be very, very common going into the new year, is employers either introducing employment contracts, written employment contracts for the first time. Maybe you've never, as an employer, had contracts before. As an employee, maybe you've never signed a contract before. So sometimes it's the first time. And then the other thing we're seeing is maybe you did sign a contract when you started, but the employer is now introducing a new contract that they want you to sign as an employee. And that could be for a variety of reasons that I'll get into. But in essence, it's a new contract that might look a little different than what you initially signed when you started, whether it was 2 years ago, 5 years ago, 10 years ago, whatever the case may be. And sometimes the contracts look very similar. And employers will tell you that it's basically the same contract, it just needs to be updated. Don't take an employer's word for it. As an employee, you need to make sure you're doing your due diligence. So in situations like that, when there's a completely new contract or an updated contract, whatever you want to call it, whatever it's being called, it's really, really important to, first of all, get it reviewed by an employment lawyer. Now, it may seem like it's not necessary at the time. It may seem like a hassle. It may seem like something that you don't want to have to do. Maybe you don't want to spend the money to pay for a lawyer to review the contract, but it will absolutely pay off in the long run. And that's because oftentimes employers are introducing these contracts for a reason. They're introducing them to limit their liability and impact your rights as an employee. So if you're an employer, you want to have a contract in place. It's a good thing for an employer because it helps limit liability. On the flip side of things, if you're an employee, you don't want to have a contract in place because they are far and large, in favor and to the advantage of the employer. And so the first thing is get it reviewed. Then the second thing, we have some questions coming in, but I will just keep going to get through some of this because I think it's really important for those who are out there in this situation, which we've seen, I'd say, an increased amount of these cases with new contracts and requests for contract reviews over the last few weeks. So I want to give general information that can help most of you that are dealing with this. So besides getting it reviewed, the things that you have to really look out for are two things: a layoff clause and a termination clause. Those are the things that employers are either inserting in contracts or revising in contracts. And the reason why it's indirectly related to the pandemic is because the pandemic has forced a lot of employers to look at this issue because they've had to put people on layoffs or they've had to let people go and terminate their employment and pay out severance. And so this issue is coming up for a lot of employers and a lot of businesses for the first time. And naturally, they're now learning about their obligations as an employer and they're learning about their liability and wanting to limit that liability. So as an employee, you have to look out for yourself as well in the face of these things and get it reviewed. And oftentimes what the employer will do is they will insert a layoff clause in the contract that allows them to put you on a temporary layoff moving forward. For most people, they are not allowed to be put on a temporary layoff as of right. So employers can only put someone on a temporary layoff if there's been a layoff in the past and that employee has come back to work, business as usual. That then creates a precedent for the future. So that's one way that it can be created. The other way that there can be a right for an employer to lay off is if the employee agrees to it in writing in a contract. And that's what's being done right now is some employers are putting temporary layoff clauses into contracts. So as an employee, you have to be very careful not to sign anything that says you agree that the employer is allowed to lay you off. Because then what happens is once you sign that, you're stuck with it. And moving forward, an employer is allowed to lay you off under the terms of the Employment Standards Act, which means they would have the right to lay you off for 13 weeks or 35 weeks if they continue your health benefits. And then if you're not recalled during that time, it would become an automatic termination. That's the way that the usual rules for layoffs work under the Employment Standards Act. So it's very important not to give that up, not to give the employer the right to do that, because then you're stuck with it. And then the second thing as an employee to look out for is the termination language. And this is where it's very important to have an employment lawyer review the contract, because very, very often employment contracts contain termination clauses where the termination entitlements are attempted to be limited. So the employer tries to limit an employee's entitlements, but it's only very specific language that actually will be effective and enforceable. So in an employment contract, the termination clause is extremely important when you get a new contract from an employer and you're an employee. You want to make sure that you know exactly what it is that you might be agreeing to. Because if you are already an employee and you've never signed a contract before, and you've been with an employer, let's say for 20 years, and this is the first contract that you're signing, and they're trying to limit your termination entitlements to the bare minimum in the province, you could be giving up your right to potentially, 20 plus months of severance versus 8 weeks in the contract. And that's why it's so important to make sure that you do your due diligence, you get it reviewed, you know what the contract says, and you don't agree to something that can really be a problem for you in the future. So these are things that we see coming up very often. These are red flags, as an employee, these are red flags that you should be consulting with a lawyer, making sure that it gets reviewed, making sure that you know what it says so that you can make an informed decision. Because more often than not, you're giving up something by signing that contract, and it's significant. And so you have to be very, very careful. And like I said, we've been seeing this issue very, very often. We've always seen this issue. Employers will, introduce new contracts at any given time, but especially because of the pandemic, this has been happening recently a lot more often. And we've been seeing an uptick in requests for consultations regarding contract reviews. So definitely make sure that if you're someone in this situation as an employee, you make sure you get your contract reviewed so that you are in a good position moving forward, and you're not going to be in a situation where you end up giving something up without even realizing it. Because once you sign it, you're stuck with it. So that's something to be on the lookout for as an employee. And of course, as an employer, it's the opposite of that. You want to be introducing contracts to limit your liability as an employer. And so that's why these contracts are being implemented. The last thing I'll say about this before I get to the questions is, as an employee, you don't have to sign a new contract. You have the ability to refuse. Don't let yourself be forced. It may be that the employer decides that they want to terminate your employment if you won't sign the contract, but you should find out if that's the case first, because more often than not, if you don't sign the contract, your employment will continue. And even if it doesn't, and they do terminate your employment, you will at least be owed your full severance. You will maintain the right to receive your full severance. Whereas if you sign the contract and then you're let go, you've abandoned your rights to full severance in most cases, and there's nothing you can do about it after the fact. So that's what I would say are the quick tips to keep in mind if you're in a situation or you know someone who's in that situation. And now I'll get to the questions as they've started to come in. So just bear with me. So I have a question actually related to what I was just talking about from Meg on YouTube, who says, the lawyer for our company drew up our contracts. So if they include the clauses you are referring to in them, how can you negotiate the contract? If I don't sign, can they put me on working notice? So as I mentioned before, if you don't sign the contract, they are allowed to terminate your employment without cause, as they are at any time or almost any time. An employer can terminate without cause as long as they provide you with your proper severance entitlements. So that they certainly can give you working notice, or they give you pay in lieu of notice or severance as part of your termination entitlements. To answer the second part of your question, Meg, the first part of your question, oftentimes it is lawyers who are drafting the contracts. Employers are going to expert employment lawyers to ensure that the contracts are drafted properly and that they're enforceable. And that certainly is what I would recommend that an employer do to make sure that all their bases are covered. But as an employee, if you're not okay with that, as I mentioned before, you have the option not to sign it, but you also have the option of negotiating. Some employers are open to negotiating. They are open to tweaking certain things in the contract, revising the termination clause, for example, so that it's more fair, so that it's something that's kind of in the middle of your full severance and the Employment Standards Act, so that the parties kind of meet halfway. That is something that we've helped people do in the past. I'm actually in the process of doing that with a few of my clients right now, where I've helped them negotiate either on their own, where I'm helping them behind the scenes with how to, counter and how to propose different revisions, or I'm in contact with the companies myself, assisting the clients in negotiating a better contract or better clauses. So it certainly is possible to do it that way. Again, some companies may refuse. Some companies may say, no, it's this contract, it's the way it's drafted, or the highway, and they are entitled to do that. If that happens, you have to make sure that you've had your contract reviewed so you know what it is you're giving up either way. So I'll just scroll to get to the next questions. I have a question from Karen on Facebook who says, I reported my boss for bullying and harassment for the last 4 years. My employer, government, deemed that they didn't feel that she violated any harassment policy. I managed to obtain a new position and have confirmed that I will start January 4th. My employer wants to implement a clause that I will have a 6-month secondment. I've been in my current position 5.5 years and I'm turning 60 in July. So Karen, I don't know if your question got cut off, but it doesn't look like there's a question here. If you want to just send in what your actual question is related to the scenario that you're in, I have all your information here. I just don't have what your specific question is. And then I'll do my best to answer your question and give you the best advice possible. And perhaps you can also let me know if you're unionized, because whether you're unionized or not, and most of the time, if you're working for the government, you are unionized, that will limit the ability, that an employment lawyer has to assist you. So if you can send in what your specific question is, more than happy to answer it. I have a question from Suzanne on YouTube who says, business with vax policy requires either vaccination, approved exemption, rapid testing, or unpaid leave for 90 days. Employees choose unpaid leave. What can happen to that employee after 90 days? So in that situation, what likely would happen, and what I've seen in many of these similar situations, is an employer will put somebody who refuses any of the options that you've outlined on unpaid leave for a certain period of time, which for you, it looks like 90 days, Suzanne. And then after that, terminate for cause, meaning terminate without severance. Now, in most cases, there will not be cause for termination. So if you're working for a company where there's no government mandate in place, you don't have to be vaccinated by law, then certainly there is an argument that you are owed severance. And it's not something that you have to wait for. So you can pursue severance if you're terminated for cause. But you can also pursue severance once you're placed on an unpaid leave. So if you're placed on an unpaid leave for refusing to be vaccinated in the face of a mandatory vaccine policy, and you are working in an industry where there is no government mandate, there is no law that says you have to be vaccinated, then you can treat that unpaid leave as a constructive dismissal, as a termination, and go after your severance pay at that time. You don't have to wait until there's a cause or for cause termination. So Suzanne, if that's your situation, definitely get in touch with us. You can go to employmentlawyer.ca and you can contact either, if you're in Ontario, you can contact me directly. I'm more than happy to help you with this. If you're not in Ontario, then employmentlawyer.ca, you can find any of my contact information or any of my colleagues' contact information, and you can contact us there in order to further assist you with this. The one thing that I will mention, because you have rapid testing in your question, and this is a question we've been getting a lot, is with respect to rapid testing, if the employer is offering that as an option and it is at their expense, and it's, for example, a frequency of once a week, that is likely something that would be considered reasonable in the circumstances. So if you're in a situation where you're refusing rapid testing, let's say once a week at the employer's expense, in some situations that would be considered an unreasonable refusal, and you may not be entitled to severance depending on the circumstances. So if you're in that situation, and I've heard from a few people who are, it's really important to get legal advice about your specific set of circumstances before you go ahead with anything, before you have a final refusal, before you outright refuse all of the alternatives and all of the options being made available, because it is possible, unlikely, but possible, that that refusal may be considered unreasonable and you may not be entitled to severance because of it. So it's really important that you know what your options are and you know what the law says about your situation so you can make an informed decision before you potentially lose your job over this issue. Just going through the rest of the questions here. So I have a question from Belinda on YouTube who asks, what about people who work contract-based positions? Are you entitled to severance if your contract is ended early and without notice? So for employees who are on a fixed term contract where it's not an indeterminate position that you can, work at this job forever, it's, a 2-year term or a 3-year term, sometimes it's a 1-year term, whatever the case may be, those contracts are a guarantee that you will be employed for that period. Whatever the fixed term ends up being, it's an agreed upon deadline of when that contract will end. So in those contracts, severance works a little bit differently than a regular employment contract or a regular employment. In a fixed term context, if the contract doesn't contain a termination clause that limits you to the minimum under the Employment Standards Act, so for a fixed term contract, if it says, for example, this contract will come to an end a year from now, unless we end it earlier. And if we end it earlier, you will receive only your minimum entitlements under the Employment Standards Act. It has to be very, very specific language. And that's why, as I said before, it's important to get it reviewed by a lawyer because it can make the difference between being owed a couple of weeks of severance versus many, many months of severance. If there's a contract that has that type of clause in it, then you may only be entitled to the minimum under the Employment Standards Act, which will vary depending on the length of that fixed term and the length of your employment. But for the vast majority of cases, either there is no termination or early termination clause in a fixed term contract, or the language that is used in those contracts to try to limit your entitlements upon termination is not the right language to actually limit you. And so in most cases, what happens is you're owed the remainder of the contract. So if it's, let's say, a year and you're terminated after 2 months, then you're owed 10 months. You're owed the remainder of the contract for without cause termination. So it's really important in fixed term contract cases to, like anything else, get advice from an employment lawyer to make sure you know where you stand, because for the vast majority of people in that situation that you've mentioned, Belinda, you're going to be owed the rest of the contract. And sometimes it can be very, very significant. So that's how that would work in a situation like that. So I have a question here from Mark on YouTube who asks, does being placed on an unpaid leave get counted towards a notice period for a termination? It's a great question. It's a very, very relevant to many people right now. The short answer is no. An unpaid leave does not count towards your notice period. And for those who don't know, a notice period is what we're assessing in terms of severance. So when we're looking at what somebody is owed as their severance pay, the amount of months is called a notice period. So if it's a 6-month notice period, then it's going to be 6 months of severance pay. And an employer can give working notice as part of the notice period. It does count towards severance. So if, let's say, somebody's notice period is 6 months and they get 3 months of working notice and they're offered 3 months of pay in lieu of notice or severance pay to get to that full 6 months, that's acceptable. And it's the same in the eyes of the law, whether the person has to work it out or they just receive pay and don't have to work that time out. It's the same. It all counts towards the notice period and towards severance. But that's because they're being paid. So working notice necessarily requires that you're working and that your terms and conditions of employment have remained the same as they were prior to your date of being notified of your termination. An unpaid leave does not qualify because it's not paid. You're not working and you're not being paid. And so the terms and conditions of your employment have been altered, and that is why it cannot count towards your notice period or your severance. If, for example, your employer notifies you that they're going to put you on an unpaid leave, and then you decide to treat that unpaid leave as a constructive dismissal and go after your severance, the notice, as long as it's very clear where the employer says on this date you're going to be put on an unpaid leave, and there isn't any ambiguity, if it's very clear that that's what's going to happen, then that period leading up to the unpaid leave can count towards the notice period. That would be the only situation where that would happen. But the unpaid leave, Mark, to answer your question, does not count towards your severance or your notice period. I have a follow-up question from Suzanne with respect to the vaccination issue. And Suzanne is asking if anything changes if the position is unionized. Yes, if you're unionized, you have to go through your union. Employment lawyers cannot assist you in pursuing anything with respect to a termination or an unpaid leave. If you're unionized, you have to go through your union. As employment lawyers, we can give you advice. We can have a consultation with you and give you advice on what you can do and what the law might say, but we cannot actually represent you, and you cannot start a court claim, for example. It would have to go through your union. So the answer does definitely change, and the way in which the law works and the way we can assist you does change depending on whether you're unionized or not. Okay, so I have your follow-up question, Karen. I'm just scrolling through here because you've provided a couple different messages. So just bear with me. I'm going to make sure I get to your question. Okay, so the question was whether your employer has the ability to implement a 6-month secondment in your new position that starts in the new year. So your question was, are they allowed to do this, which caught you by surprise in the offer letter. So in terms of are they allowed to do this, it will depend on how significant of a change this is. So given your situation, Karen, I recommend that you get in touch with us to discuss this further because it's a little bit complex and complicated, and I'm not able to give you a comprehensive answer based on just the information you've provided. What I can tell you more generally is if this kind of secondment has never been part of your employment before, if it really is altering the regular terms and conditions of what your employment has been these past 5.5 years, and it's a significant change, it may be something that you can push back on. If it's not a significant change, then there may not be very much that you can do about it. And this applies to all types of changes. So as an employee, the employer can make certain changes to the terms and conditions of your employment. They can be subtle. They may be changes that you don't like as an employee. Often that's the case, but certain changes can be acceptable from a legal perspective. So it's not every change that may amount to a constructive dismissal. It has to be a change that's permanent and that's a significant change to the fundamental terms of employment. So the most common examples are, a decrease to your salary, a change of work location. That means you're going to have to commute an extra hour each way, things like that, a demotion. Those are all examples, and they're more extreme examples of things that you can push back on that are constructive dismissals that you don't have to accept. But some changes that are very subtle, that are not significant changes, are not things that you can necessarily push back on. So every single case where there is a change being proposed or forced upon an employee, you have to get legal advice, because there are no two situations that are exactly alike. And in order to make sure that you're getting, the proper legal advice, an employment lawyer would need to review all of the circumstances in order to give you an opinion on whether this is something you can push back on and refuse, or whether it's something that doesn't provide you with much legal recourse. And so for you, Karen, I do recommend that you get in touch with us to have a consultation with one of our lawyers for a more in-depth review, because we'd have to see the totality of the circumstances of your employment, all of the terms and conditions, the precedents in the past, what's the history there. All of these things will allow us to assess your situation and let you know if there is something that we can do to help you if you don't want to agree to that secondment or anything else that they're changing for that matter. So you can definitely get in touch with me. If you're in Ontario, I'm more than happy to help you. I practice law in Ontario. If you're not in Ontario, I'm more than happy to connect you with one of my colleagues who can assist you. But the first step really for you, Karen, and anybody who's in a similar situation is get an assessment by an employment lawyer first. Figure out what it is the situation actually provides for from a legal perspective. What are your options, if any? Sometimes, unfortunately, there aren't any. But if there are options, that's the first step. Figure out what they are, and then you can make an informed decision from there and see what your best course of action is to move forward. So that's what I would recommend that you do here, Karen, and I'd be more than happy to assist you, or one of my colleagues would be more than happy to assist you. Just scrolling through the questions here. We have a couple more minutes left. So I have a question from, it looks like someone in the States. I just wanted to mention our law firm is in Canada. We're in Ontario, we're in Alberta, we're in British Columbia. Those are the provinces in which we practice. So we are more than happy to assist people who are in those provinces. Unfortunately, we're not able to assist if you're in the United States, but you should definitely contact a lawyer in your area to ask those questions. I have one more question. I'll get to one more question before we end here. I have a question that was emailed in from Melinda, who says, I am employed in a city building which has been sold and will likely change hands next year. I have worked the same position over 10 years, but the city has hired various contracted employers to oversee my job. My current contracted employer has employed me for over 4 years. It is possible my current contract employer will move me elsewhere, but I can't imagine they would have a full-time position which would equate to the one I currently have. If the new owners dismiss me with their takeover, who is responsible for my severance, the city or the contracted employer? Will I be compensated for all the time I actually worked in the job, or just for the time that my current contracted employer has hired me? So I think what you're describing, Melinda, and we'd have to confirm. So I do recommend you get in touch with us, because your situation is a complex one and one that we do see every now and then. What looks like is a building service provider issue. So oftentimes if there's a building and there's a maintenance contract, for example, there will be an RFP and there will be different contracts throughout the years of different service providers coming in and offering those maintenance service, cleaning, maintenance, those types of things. And the employees may remain the same, and your job may remain the same from one provider to the next, from one contract to the next, but your length of service would continue. So to answer one of your questions, in terms of termination entitlements, it does go back to the beginning, and the city would not be your employer in the scenario in which we're describing. It would be the building service provider. And so if, let's say, the building service provider who is currently won over the contract and who is currently the employer under which you are employed, if they decide to let you go, they are responsible for your severance, going back the entire time to when you first started in that job. So that answers, I think, most of your questions. I'm just reviewing here who would be responsible. As I mentioned, the contracted employer. And yes, it would be, so you wouldn't be, in other words, compensated for the whole time. But when we look at severance based on your age, your length of service, your position, your compensation, all of those factors, the length of service would go back the whole way, all the way to the beginning. And there's very, very specific sections of the law that apply to changes in the building service provider. So whenever you're met with a situation like this, like yours, Melinda, it's really important to get legal advice, because the law does work a little bit differently for these types of situations. So if you are in a situation like Melinda's, certainly make sure to get in touch with an employment lawyer. You can contact us at employmentlawyer.ca. You can email us at help@employmentlawyer.ca to make sure that you have a lawyer review your situation, because as Melinda's question has made very obvious, it's not always clear who's liable and how your severance is calculated. So it's something that comes up often enough, and you want to make sure that you're covered in case you are let go, and that you make sure that you get your full severance. So that was the last question that we have time for today. Thank you everyone very much for joining us. Thank you so much for your questions. This will be the last Facebook and YouTube Live of the year. So thank you very much for joining us, everybody, all year long. And we will be back in the new year, first week of January, to continue to answer your questions at these weekly sessions. So for now, I wish everybody watching a very happy holidays, happy new year, and we will see you in 2022.